Welcome to the final round of the 2021 first ever virtual Roger J. Traynor Moot Court Competition. Please forgive the cliche, but I wanted to start by saying I wish we were all able to be together in person. But I am so grateful as the Traynor administrator for everyone's cooperation in making this remote event so successful. A huge part of that was because of our host school, the University of West Los Angeles School of Law. So I would like to just take a moment to thank the president of UWLA, Robert Brown, and the dean and provost, Jay Frickberg. They generously allowed us to use the physical campus in a safe, socially distant way, so that we could supervise the Saturday rounds yesterday with our bailiffs in person. So thank you so much. Jesse Aldava, who is our Director of Institutional Research and E-Learning, with Mauricio Canad, Library Services Manager, set up all the Zoom rooms and troubleshot for us. So thank you to them. Thank you to our able and dedicated student bailiffs, Jacqueline Anderson, Arpi Sislian, Yassi Terani, Shushan Yeremian, and Ani Zakarian, who came yesterday and spent the day with us and made the entire competition possible. And thank you to all the judges who came yesterday and devoted their entire Saturday to this event. The Traynor was made possible by a generous grant from the Gisnet Mandel Moot Court Trust. Special thanks to Patrick and Ingela Pigot. Lunch for the judges was made possible by our gold sponsor, Esner, Chang and Boyer. So special thanks to Stuart Esner. And a reminder that everything about the Traynor, there's a competition program, a synopsis of the case, the list of winners, past winners. Everything can be found on our website, traynormootcourt.org. So check that out there. I want to make sure we're recording. We are. Great. Well, now what we've been waiting for, our final round between Team 3 for appellant and Team 10 for the respondent. Today, as our judges, we are very excited and honored to welcome the Honorable Arthur Gilbert, the Honorable Helen Bendix, and the Honorable Elwood Lui. And acting as our bailiff today is David Glassman. He is a decades-long supporter of this competition. We thank him. And now we turn the proceeding over to him.
Good morning, everyone. Welcome to the final round of the 2021 Roger Traynor Memorial Moot Court Competition. This is the case of People of the State of California versus Peter Prescott. The appellant, Peter Prescott, is represented by Michael Sulemazian and Catherine Willis. The respondent, State of California, is represented by Patricia Snyder and Dahlia Maya. Each team has a total of 30 minutes. I will keep time and I will display the intervals of time as I reviewed with the advocates. I would like to first, before we begin, ask each advocate in the order of presentation to introduce themselves and to spell their name, please, starting with Mr. Sulemazian.
Good morning, Your Honors. Michael Sulemazian, M-I-C-H-A-E-L, last name S-E-U-Y-L-E-M-E-Z-I-A-N.
Good morning, Your Honors. Kate Willis, K-A-T-E-W-I-L-L-I-S.
Good morning, Justices. Patricia Snyder, P-A-T-R-I-C-I-A. Snyder is S-N-Y-D-E-R.
Good morning, Your Honors. Dalia Maya, D-A-L-I-A, last name M-A-A-Y-A-H.
Thank you all. Mr. Sulemazian has requested 2 minutes of rebuttal. Unless there are any questions or if the court is ready to proceed, Justice Gilbert, let me know. And if so, I will ask Mr. Sulemazian to proceed.
I think we're ready to proceed. Thank you.
Thank you, Your Honor. Mr. Sulemazian, your time.
Well, yeah, excuse me. I just want to make a few preliminary comments. I want to welcome you all on behalf of my colleagues, Justice Bendix, Justice Elwood Lui is the administrative presiding justice of the entire 2nd District. And he and I have known each other for years, and we're all good friends. We all know each other, and we're on different divisions of the 2nd District. I thought that might be of interest to you. Now, we tend to be somewhat of an active court, depends, and we may interrupt you. I know that may be annoying, but that's what happens in real life. And the reason we do that is because we we might have an idea about the case, and it helps you because you know what our thoughts are about the case. Now, how do we interrupt you on this Zoom meeting? We generally put our hands up like this. That's what I do in my division. So if you see a hand coming up, you got to sort of be aware of what's on the screen because we might want to interrupt you. We try not to, but on certain occasions, we have an idea and we want to pursue it. Okay, with that, with those few comments in mind, let's begin with Mr. Sulemazian. Go ahead, sir.
Sulemazian, you may begin.
Good morning, and may it please the court. My name is Michael Sulemazian, and I, along with my co-counsel, Mrs. Kate Willis, represent appellant, Mr. Peter Prescott. I will be addressing the excessive force issue and the jury instruction issue, and Mrs. Willis will be addressing the ability to pay issue. We have asked this court for 2 minutes of rebuttal.
Sure.
The criminal justice system failed Mr. Prescott. From the manner in which he was arrested all the way through his treatment at the sentencing hearing, Mr. Prescott was ignored by both the officers and the trial court. This was a miscarriage of justice. Mr. Prescott's Penal Code Section 69 convictions should be reversed because both Officer Dawson and Officer Drucker used excessive force when arresting Mr. Prescott. The facts of this case—
excuse me, was Mr. Prescott violating any kind of law, however minor that law may be, during this time, when they first confronted him?
Your Honor, the officers first stopped Mr. Prescott for potentially violating a traffic provision of discarding his ashes of a cigarette while he was walking down the street.
What do you mean by potentially? He was or he wasn't?
Your Honor, the officers saw Mr. Prescott smoking a cigarette and decided to stop and either warn him or cite him for discarding his ashes. So the facts of this case began with a man who went to the store to purchase some cigarettes. It ended with Mr. Prescott being tased, tackled, and punched in the head repeatedly. How we went from Mr. Prescott simply walking down the street smoking a cigarette to face down on the ground receiving multiple blows to his head by 2 officers is central to this issue. As we go through this analysis, it's important to consider what an objectively reasonable officer would have done here and whether or not we would have had the same results. Officer Dawson and Officer Drucker's escalation of violence towards what was a cooperative and calm defendant is more than unbecoming, but it is excessive force. To determine if excessive force was used, courts apply the Fourth Amendment reasonableness standard to balance the nature of force used by the officers against the relevant governmental interests at stake here. Although this reasonableness standard does allow for split-second decision-making by police officers, we can see that in this situation, not all of the decisions were split-second. Officer Dawson and Officer Drucker had many opportunities to de-escalate the situation and keep a calm confrontation calm.
Didn't he
They failed-
resist? Excuse me, irrespective of how unreasonable you may think the stop was, there was some resistance on the part of Mr. Prescott, wasn't there?
Yes, Your Honor. The stop, we don't contest that the stop was unreasonable. Rather, it was the manner in which Mr. Prescott was arrested that was unreasonable.
Right,
Mr.
but did that happen in a vacuum? When the officers approached him, didn't he, or they were talking to him and even just approached him, didn't he make some kind of tense up or try to pull away?
Yes, Your Honor, Mr. Prescott did tense up and pull away, but only once Officer Drucker tried to grab him without warning. Officer Drucker and Mr. Prescott were having a calm conversation about Mr. Prescott's newborn child. Mr. Prescott's actions in this.
Well, was it unreasonable for him to assume when he ran a warrant, he got his name, so he went to the car and ran warrants. And I think that's probably always what they're doing. They came back and they tried to handcuff him. It seems to me that at that time he had the ashes thing, how minor that was, plus an indication that he had outstanding warrants. So we have to judge that against the officer's conduct. What would you have the officers do? Say, stop, I'm going to handcuff you because you have outstanding warrants, and therefore I'm going to give you a warning, or should I just try to handcuff you and presume you're not going to resist by tensing up? So that's what's facing the officer, isn't it? Isn't that the correct assessment of the situation?
Yes, Your Honor. However, there are certain requirements that an officer must follow, and this is because the legislator has recognized that people don't always know that they're being taken into custody. Not all interactions with the police end with the suspect being taken in. And here, there was nothing that Mr. Prescott should have reasonably known that he was being taken into custody. This is why we have Penal Code Section 841 that requires that an officer clearly inform citizens that they're being taken into custody. Although there is no strict timing on when the officers need to do so, it was reasonable in this circumstance. The officers had ample opportunity to simply tell Mr. Prescott he was being taken under arrest.
What was the trial court's rationale for not granting the motion to dismiss the 1118 motion and sending it to the jury?
Your Honor, the rationale there was that there was conflicting evidence as to whether or not Mr. Prescott's behavior posed enough of a safety threat to the officers' concerns that they were therefore exempted from Penal Code Section 841's requirement.
Shouldn't that matter go to a jury to decide rather than a court as a matter of law?
No, Your Honor, because of the jury instruction issue in this case, we had the trial court improperly instructed the jury on Penal Code Section 841. And we can see that there is evidence in the record here that Mr. Prescott was behaving reasonably and did not pose a substantial threat. So when we balance the nature of force used by the officers against the governmental interests at stake, courts weigh three different factors to measure that governmental interest: the severity of the crime at issue, the immediate threat posed by the suspect at the time, and the active resistance and evasion of the suspect. So the severity of the crime here is these undetermined warrants that Mr. Prescott has. And courts have held that undetermined warrants are not alone enough to justify a substantial use of force by the officers. And this is because undetermined warrants can be for a variety of different crimes. They could be for misdemeanors or nonviolent felonies.
Excuse me, but doesn't the fact that there's an outstanding warrant contribute to an officer's assessment of risk to public safety or his or her own safety?
Yes, Your Honor.
They're not unrelated, are they?
Yes, Your Honor, you're correct. They are not unrelated. However, it's important that when Officer Dawson discovered undetermined warrants and didn't know what those were for, it was not enough for him to then be on a higher level of alert to employ a higher level of force. We can contrast this from when if Officer Dawson had ran those warrants and discovered that Mr. Prescott was wanted for an armed, very violent felony, that is the type of warrant that would justify a substantial use of force. But when it's unknown to the officers, that is not enough. When we look at the second fact,
Does 841 come into play at just the very first interaction with the officer? Or could it come into play during the course of the arrest? The reason I'm asking is the fact that the officers appear never to have told the defendant that what the nature of his offense was.
yes, Your Honor, you're correct.
And is their obligation is it a continuum of an obligation, or only when they first interact, you're pulling his hand back for it?
5 minutes remaining.
Yes, Your Honor, you're correct. This penal code
I'm
section
asking you, I
requires.
don't know the answer to that question.
Well, Your Honor, Penal Code 841 requires that at some point during the arrest, the officers inform the arrestee of the intent and cause. Here, we would argue that the officers in this case should have said that at the beginning. However, even if they did not do it at the beginning, they had the opportunity to do so at any point. And throughout the entire course of these events, Mr. Prescott asked several times, what is going on? What is happening? And the officers ignored Mr. Prescott. Penal Code Section 841 especially requires an officer to inform of the intent and cause when the arrestee is actively asking the officer what is happening. The officers at trial here testified that they simply did not remember what Mr. Prescott was saying throughout this interaction.
So you would favor having him be told that before they secure his custody? In other words, before they put the handcuffs on him, you got to tell him what's going on. Is that what you're saying?
Yes, Your Honor. In this case, given these circumstances, prior to grabbing,
we don't know what the outstanding warrants are. And the fact that he has an outstanding warrant could be minor, it could be serious. And so do you favor telling a arrestee, even on these unknown situations, that he should be told of the outstanding warrant before his physical custody is secured, or after?
Your Honor, we would still be in favor in this situation prior to grabbing Mr. Prescott, because I want to emphasize that these unknowns, it's not permissible for the officer to assume the worst in all of these circumstances. These unknown warrants could have been for a misdemeanor.
Let's take a look at, we're concerned about the safety of both the officer and the arrestee. Would it be better to have the arrestee be secured and then told what it is, or would you do it before and then there's a possibility of fleeing? I mean, we're talking about balancing the security interests of the arrestee and the officer. You would favor still that telling the arrestee, before I put the handcuffs on you, you're being arrested for outstanding warrants, which we don't know about, but you have outstanding warrants. That creates somewhat of a danger.
Your Honor, even under that evaluation, if we said it was better for the officers to get Mr. Prescott's hands behind his back first, they still had multiple opportunities throughout the situation to tell Mr. Prescott he's under arrest and therefore comply with Penal Code Section 841. They simply refused to do so here. The officers said that they didn't have time to do that. However, they had plenty of time to repeatedly tell Mr. Prescott, stop resisting. When Mr. Prescott here was scared, and on reporter's transcript, page 358, Mr. Prescott testified to the fact that he felt like he was being attacked. Turning to the jury instruction issue,
2 minutes remaining.
The trial court here improperly lightened the prosecution's burden with argumentative jury instructions. The standard
even if the officers don't have cause to stop and arrest Mr. Prescott, is there a responsibility on the part of a citizen just to submit to the arrest and then, instead of trying to resolve it by resistance on the street, resolve it in a court of law in a different way?
Your Honor, there is some responsibility on the citizen. However, it's important that the burden of this responsibility falls on the police officers to behave appropriately. We're here to evaluate Officer Drucker and Officer Dawson's behavior. Mr. Prescott acted reasonably as anyone would when he's grabbed without warning. That's not a reasonable behavior of the officers. So the jury instructions here were argumentative because the trial court completely omitted the two statutory exceptions to Penal Code Section 841 and simply emphasized for the jury that the officers may be exempted from 841 if the defendant's behavior was resistant. And it said when issuing these instructions that this arrest otherwise lawful does not become unlawful when the officers fail to comply with 841. This was argumentative and it was not harmless beyond a reasonable doubt, given the fact that these officers were not exempted from this Penal Code Section 841 requirement. In light of all these considerations, we respectfully ask that this court reverse Mr. Prescott's Penal Code Section 69 convictions. Thank you.
Thank you.
And we'll next hear from Ms. Willis.
Ms. Willis, you have 15 minutes.
Thank you. Good morning, and may it please the court. My name is Kate Willis, and I will be addressing Appellant's second issue, the trial court's failure to consider his ability to pay his fines and fees and the denial of an ability to pay hearing at sentencing. As my co-counsel described, Mr. Prescott faced a miscarriage of justice from his initial encounter with law enforcement to the jury instructions that would decide his fate at trial. The violation of his legal rights continued at his sentencing hearing. In addition to a prison sentence of 6 years, Mr. Prescott was sentenced to $640 in fines and fees. Mr. Prescott had a right to a hearing to dispute these fees based on his inability to pay them. However, the trial court failed to allow him to dispute his restitution as required by Penal Code Section 1202.4.
But let me ask you this. I understand the trial court didn't do that. What are the consequences of Mr. Prescott not paying the fees? Let's assume he didn't pay the fees. What are the consequences? What I'm driving at, would his jail time be increased? Would he be in custody if he didn't pay the fees?
Your Honor, no, his jail time could not be increased because the Supreme Court has previously held that is unconstitutional. However, not being able to pay the fines right away would result in a spiraling of Mr. Prescott's debt, because if a defendant cannot pay their fines and fees, eventually the court sends that into collection, and then those amounts grow and grow.
But that's
Yes.
a future problem, isn't that right? It's not a present day problem. It's in the
Correct.
future.
Yes,
So
Your Honor, that is a
At the time
future.
that the fees are imposed, how is there any restriction on him? It doesn't have any present context.
Well, Your Honor,
We're interrupting you because Justice
No, I want to please finish.
wants to
Ms. Willis,
follow up.
I'm interested in your answer. Maybe you'll answer my question while doing that. Okay.
okay, so I'll answer Justice Liu's question first. So the reason it is important to hold that ability to pay hearing immediately at sentencing is because that fine is due right away. And in the case People v. Duenas, which I'll talk about coming up, the court held that as a matter of due process, the defendant's ability to pay at that moment must be considered at this hearing.
Well, there are a few courts, including my court, does not agree with Duenas presently, because and one of the problems is the other prong of your argument is that the court must determine. I have a hard time with the concept of anyone but the defendant being able to bear the burden of payment, because I don't know what his resource, if I was a judge, I wouldn't know what his resources is. He should speak up and say, I don't have the ability to pay. And it's not presently a problem. It's when he gets out of incarceration, when those fees are expected to be paid. During the time of incarceration, he earns fees on working in the prison system. But I have a second problem with Duenas in the sense that how is a court supposed to make that inquiry? And have the burden of making that inquiry.
Your Honor, we are not suggesting the court provide the inquiry. The holding of Duenas is that this, as a matter of due process, this hearing must be held. And at this hearing, the defendant would bear the burden of presenting evidence on their financial situation and show whether or not they have the ability to pay. Then the court may take that into consideration when determining the fines and fees. And this is reflected in Penal Code.
I'm interrupting you, I'm sorry, because I think Justice Bendix has a question that will go to this very issue.
Well, you've mentioned 3 times it's a violation of due process. Why is it a violation of due process? He hasn't been denied access to the courts.
Your Honor, the holding in People v. Duenas that it is a denial of due process is based on the fact that unpayable fines place a much greater burden on indigent defendants than wealthier defendants. And the constitutional guarantee of due process is to ensure that everyone is treated equally under the law. But if you consider a defendant's ability to pay who has less money than one who has more money, that burden is greater on the indigent defendant, especially considering these collateral consequences that are a result of a growing debt. An indigent defendant may face total loss of credit for being unable to pay this debt, and as such, they may face a loss of their job or a loss of housing, and this not only affects them, but their families.
Okay. Now you said the burden is on who? Is it on the defendant or defendant's counsel to bring it up?
Your Honor, yes. Our position is that one, the burden is on the defendant to request this ability to pay hearing.
Okay, and then the burden of showing that, that's on the defendant?
Yes, it is our position that that is on the defendant, and this is in accordance with the penal code section that says the burden is on the defendant.
I'm going to interrupt you again. Let's assume that happens, and the judge says, okay, you don't have to pay the fine. Does that mean he doesn't have to pay the fine ever, right?
Yes, Your Honor.
So if he wins the lottery, or he inherits from a wealthy uncle, too bad he doesn't have to pay.
Yes, Your Honor. If we are looking at the defendant's present ability to pay, which is consistent with the holding in Duenas, then it won't matter in the future. And in Mr. Prescott's case, he's going to prison for 6 years, so his circumstances are unlikely to change.
Yeah, that could be. You know, it's interesting. 3 of us are from 3 different divisions, and I think we all agree. I don't know if Justice Bendix does. I think so.
I wrote to Paris, so I have a different take a little than Justice Hofstad did in division.
Yeah, I agree with Justice Lui in the sense that we think Duenas is wrongly decided. We don't follow it. The Supreme Court may have a different point of view, and we're just waiting for the Supreme Court to finally decide the case so we can move on with some other issues. But go ahead.
Yes.
Can I follow up on this? Because why isn't Duenas confined to its unique facts? And the statement behind my question is that her poverty led to her criminal conduct, driving with a suspended license. But in this case here, no, I don't think one can argue that Mr. Prescott's financial situation led to the reason he's in front of us now.
Yes, Your Honor.
Why is Duenas, again, focusing on the due process? You're saying it's a matter of constitutional law, since every defendant's entitled to an inability to pay hearing. I have trouble with that concept because I don't see how access is being denied to the court but I'm going to ask you to answer my first question, which is why shouldn't Duenas be confined to its very unique facts?
Yes, Your Honor. And I know the court has raised this in various cases, but yes, Ms. Duenas' circumstances were very extreme and quite tragic at that. However, due process is a constitutional principle, and that is universal to all criminal defendants, regardless of their circumstances. And furthermore, a defendant's circumstances cannot truly be discerned unless they are given that opportunity to show whether or not they can pay. And then can you repeat your second question, please?
I think you answered it.
Okay. I also wanted...
Well, what's wrong with this? What's wrong with this? The court can provisionally say you've got to pay these fees. And when he gets out of prison at an appropriate time, make a motion to the court and say, look, I can't pay these fees. While I'm in prison, what I get for sweeping the floor or something is minimal. I'm never going to be able to pay it. But look, I'm still in this condition. Would that be an undue burden and a violation of due process?
Your Honor, I see how that could be a potential solution. However, I believe if we're looking at a universal solution and one that could potentially be, well, the Dueñas Court recommended this statute 1202.4 be amended because those procedures are unclear. And in response to, staying the fines until one is out of prison, not every defendant in this situation will go to prison. Ms. Dueñas was only sentenced to a misdemeanor. So it's more, it makes more sense to have the process be the same for every defendant so you can address it right there at the sentencing hearing. And hopefully the legislature, yes.
Excuse me. Many defendants are sentenced to decades in prison. The fees here were the lowest that the court could have imposed. Why couldn't they, going back to Justice, I think it was Justice Gilbert's question, why would not his prison earnings be sufficient to pay those fees? And I believe that's the Johnson case. Why is it a harmless error?
Yes, Your Honor, 2 points on that. Actually, his restitution fine was above the statutory minimum, which is $300 for a felony, and he was given $500.
I misunderstood. All right, but the same point.
But regarding prison wages, according to the California Code of Regulations, I believe this is Title 15, Section 8006, there's a pay scale for prison wages, and it ranges from 30 cents to $1, depending on how the prisoner may move up in their prison jobs. So in 6 years, he may or may not, earn that amount that he owes. However, also not every prisoner is eligible to work in prison, and we don't know Mr. Prescott's situation. But I also want to highlight the fact that often defendants in this situation, indigent defendants, not only do they need to worry about paying off their fines and fees while they're in prison or after prison, but Mr. Prescott has a newborn child to support, and many defendants also use prison wages to support their families and to support themselves while in prison. You need some money to buy necessary things. So
a question, and again, it may not be, maybe it's not, there's several things that the criminal law imposes. If you get a DUI, you have to install, let's say, a machine in your car so you breathe into it before you can drive and check your blood content. All those kind of things. You're saying that every time the law imposes, the legislature has imposed such a condition to probation, it's a due process violation, the person can't afford it?
Yes, Your Honor. However, that's a different issue than in Dueñas.
Why is it different?
Because that, I believe that was already decided by the Supreme Court, and the case, I believe, is Bearden. Yes, my apologies. In Bearden, the question was, can you jail a defendant or sentence them?
No, I didn't say jail them. I didn't say it can be you jail. But my question is, if you get the privilege of probation, if you're indigent, let's say, or poor, I assume you're going to argue that your court can't condition probation on requiring someone to install a breathalyzer, whatever they call it, in your car because they're poor and they can't afford it, and therefore they don't get probation. They have to go to county jail, let's say.
Your Honor,
I'm trying to think of the logical conclusion of your argument, because there are many things that the legislature has imposed once someone is convicted. And my question is do you think that due process requires an ability to pay hearing for each one of those? If someone is, let's say, if someone has a public defender.
1 minute remaining.
Your Honor, I would argue that appointment of a public defender, such as in Mr. Prescott's case, should create sort of a presumption of indigency. But Our position is only regarding the fines and fees element. There's, endless things that could be discussed, but I would like to point you to People v. Bearden, the Supreme Court case I mentioned, and that court held that while there is this government interest in punishment and deterrence for people who commit crimes, that interest should be served by alternative means that don't violate an indigent defendant's due process rights, and that deprivation of 14th Amendment liberties is not permissible simply because a defendant does not have the ability to pay a fine.
Would you agree? Well, would you think this would be appropriate? If you can't pay, you're going to have to do some community service. You're going to have to do some work cleaning up parks and do something like that.
Your Honor, I see I'm out of time.
I'll let you finish. Go ahead.
Okay. Yes, Your Honor, I would argue that is a reasonable solution, as long as the burden isn't greater on a poor defendant than a wealthy defendant. That's the whole issue at stake here.
Of course, the wealthy defendant wouldn't have to do community service. But
right. So it could possibly be unequal treatment in that situation.
Okay. Time is up. Thank you.
Okay. Thank you. May I just briefly conclude?
Well, all right. You got 15 seconds.
Yes. I just want to emphasize the remedy we're requesting here, which is that this court stay Mr. Prescott's fines and fees until it can be considered on remand at an ability to pay hearing where he can present evidence on whether or not he can pay them.
Okay. Have another hearing on that. Yeah.
Yes.
Thank you.
Thank you.
The first advocate for the respondent is Ms. Snyder. Ms. Snyder, you have 15 minutes when you're ready.
Hello, Ms. Snyder. Welcome.
Thank you. Thank you. Good morning, Justices.
Good morning.
May it please the court, my name is Patricia Snyder, representing the respondent, the people of the state of California, together with Ms. Dalia Maya, co-counsel. I'm going to demonstrate why the appellant's arrest was lawful and his conviction should be affirmed. Ms. Maya will demonstrate why the court was not required to hold an ability to pay hearing prior to imposing fines and fees.
Yeah, go ahead.
Appellant contends that he was ignored by the deputies and that the use of force against him was unreasonable. But the jury in this case found substantial evidence that this arrest was lawful because—
of course, the question is, should this have even gone to the jury? I'm going to back up and ask you something right away.
Sure.
People can smoke in public, right?
Yes.
Yeah, outside. I mean, a restaurant might understand that. And when people smoke, how do they get rid of their ashes? What do they do?
They ash in an ashtray or a proper ash.
Okay. Oh, really? Well, I've walked down my street and many streets, I don't see any ashtrays around. And even though I'm not a smoker, there still are, a lot of smokers left, and I see them flicking their ashes. What are they supposed to do?
I understand what you're saying, Justice, and the officers do have a right to make pretextual stops. And when they stop, yes, Your Honor, they—
What do you mean by a pretextual stop?
Well, if they have a reason to stop somebody for the violation of a code, in this case, it was a vehicle code that requires that people do not ash, burning embers on the sidewalk and outside of a proper receptacle. So that is why—
If they're walking down the street and see somebody well-dressed in Beverly Hills on Cannon Drive, for example, smoking a cigarette, wearing an Armani suit, looking in one of the fancy stores and has a cigarette, do you think any officer is going to stop that person in real life? Let's be honest. You think that's going to happen?
Those were not the circumstances that occurred in this case. So I could speculate as to what an officer in Beverly Hills would do under those circumstances, but that is not what happened in this situation. Okay. So these officers did stop him for ashing on the sidewalk, and they began a conversation with him. And now they ended up running his name to check for warrants. And now he claims that the arrest was unlawful because the officers failed to comply with 841. But under the circumstances, as I will highlight them, full compliance with 841 was not required. And the officers' use of force was reasonable because it was in direct response to appellant's forceful resistance. And finally, the jury.
Right.
Yes.
Miss Justice Bendix, please.
So why couldn't the officers, when they were handcuffing him, or before they tased him the second time, tell him he's being arrested for the outstanding warrant?
Well,
I mean, in other words, there's a relation between his resistance and not knowing why they were stopping him. I think that's what Justice Gilbert's questions are. I mean, most people would not expect to be confronted by two policemen and almost put in a handcuff till he wouldn't let him, just because he flicked ashes on the sidewalk. So I'm concerned about that. This is a continuum of conduct, and at some point, why didn't the officers just tell him why they were confining him? I don't want to use the technical term. Just trying to do him.
Deputy Drucker testified at trial that when he received the 1015 code from Deputy Dawson, he turned to appellant and said, put your hands behind your back so you can be handcuffed, so you can be arrested. So under those facts, which are the facts that the jury presumably believed and convicted appellant based on, Deputy Drucker did tell appellant that he was under arrest.
Yeah, but
And
doesn't
at that
the statute
him-
require you to say what the offense was?
It
Yeah.
does. It does. And as soon as Drucker said, put your hand behind your back so you can be arrested, appellant's demeanor immediately changed. He immediately started backing away and saying no. And so based on Deputy Drucker's training and experience, he believed that appellant was going to flee. So he
What
reached
about-
out.
Yeah, what about, I'm sorry, I'm interrupting you, but that's kind
Okay.
of in real life, in real court.
No, it's great.
What about penal code section? What is it, 841?
Yes,
Aren't you supposed to tell them why you're arresting them?
you are. But my point is
I'm
that the
arrested, for
deputies.
example, wait, let me finish, please. I know you want to get it out, but judges often do this. But shouldn't they have said, we're arresting you because you have warrants, and tell them what it is? That whole situation might have been diffused. Isn't he required to do that? He admitted on the stand he didn't do that.
They were not able to because appellant immediately began to forcefully resist them. Under
Wait a minute, they didn't tell him. If they didn't have to do anything, they said, we're gonna have to arrest you because of you have outstanding warrants. You said he didn't give him a chance. He starts handcuffing him immediately.
Deputy Drucker told him to put his hands behind his back so he could be handcuffed and arrested. And then
Yeah,
appellant immediately began to resist. And
but he didn't know what, my point is, he didn't know why the officer told him to do that. Doesn't the officer have an obligation under the code section to say what I just said? We're going to arrest you. We have to arrest you because you have warrants.
yes, but the case law illustrates that the officer's uniform is sufficient indicia to prove their authority to arrest and to satisfy the requirements under 841. These deputies were in full uniform with their badges visible. They were in a marked sheriff's.
I gotta stop you again.
Mhm.
Are you saying that 841 only applies to uniform officers, but not to plainclothes detectives?
No.
Well, isn't
no.
that the logical import of what you're saying?
I am saying that it would be more important to comply fully with 841 where an officer is in plain clothes. But in the case of In re Ramon T, there was an off-duty officer in street clothes, and the court held that his badge, showing his badge to a group of teenagers he was trying to arrest, was sufficient indicia to meet the requirements of 841.
Did the officers ever, even after he was finally sustained, I mean, he was placed into custody, did they ever tell him what he was arrested?
They did not have the opportunity. This was a very.
Well, I mean, they got him in a police car and he's going in the back of the car and locked up. Couldn't they have said, well, you're being out, you had an outstanding warrant, that's why we arrested you? They didn't do that.
So appellant was not subdued until backup officers arrived on the scene. And even then they had to get a hobble on his legs to prevent him from kicking because of the amount of force he was using in resisting this arrest. And so after the backup officers arrived and they subdued him, they took him away, and Deputies Drucker and Deputy Dawson had no further contact with him. So that is why, yes.
Are you finished responding to Justice Louis' question? I didn't want to interrupt you.
Thank you, yes.
Okay, is there anything in the record to indicate that the defendant knew he had an outstanding warrant?
No, the appellant did not know that he had outstanding warrants, but he knew that they were running his name for warrants. He was standing there waiting for them to finish. So he should have known under these circumstances that he was being arrested. As I said, the officers were in uniform. He knew they were running his name. They told him, put your hands behind your back so you can be handcuffed and arrested. He immediately attempted to flee. Once Deputy Drucker grabbed his wrist to prevent him from fleeing, his elbow flew up into Deputy Drucker's face with such significant force that Deputy Dawson believed, based on his training and experience, that appellant was going to assault Deputy Drucker. So he attempted to get appellant's other hand so they could get his arms behind his back. At this point, Deputy Drucker could not have known what the warrants were for, the severity of the crime. The deputies had not had an opportunity to frisk him, so they did not know if he was carrying weapons. So this was an extremely volatile situation. In People versus Braun, the court found that full compliance with 841 is not required where an officer believes that full compliance will increase their peril. And that was the situation that these deputies were in. They were trying to de-escalate and make sure that they could effectuate this arrest safely.
I'm going to just introduce an element here. Are you familiar with the street term called aroused?
I am not.
Okay.
5 minutes, 5 minutes.
Aroused occurs when an officers just want to stop somebody because they got this feeling in their gut that we're going to get this guy. And so I'm suggesting that some triers of fact or some court would say, are you kidding? It goes back to my first question about who the person is. People have cigarettes, there's not ashtrays in the street. It just looks kind of funny that they would stop this guy. And you're saying, well, they can do it. Yes, they can do it, but there's law and there's the real world. And courts have to look at what goes on in the real world. And there's an argument here that these cops used a highly technical argument to stop this guy, and they're not articulating why they really stopped him. How do you respond to that?
I would say that again, once they found out that he had warrants, they had an authority to arrest him. And under Penal Code Section 834A, he had a duty not to resist the arrest. So once he began to behave as if he was going to flee and then assault them.
Okay, let me ask, I understand your response. Let's assume he didn't have warrants. Were they justified in stopping him?
Your Honor, there is nothing that says that officers have no right to stop and talk to people that they see walking down the street. Officers may stop and talk. And appellant argued the Fourth Amendment unreasonable search and seizure, but that doesn't apply here because the officers merely stopped to talk to this individual. They got his name and his birthday so they could run his name for warrants. They found that he had multiple outstanding warrants. And at that point, they had authority to arrest him.
So your position is the record would support that he could have just walked away if they asked him his name. You're saying it's completely a consensual discussion? Is that what I'm trying to understand your answer?
At that point, he could have just walked away.
Okay.
But that is not what happened.
Could he have walked away when he is, despite the fact that this ashing is maybe not a preferred charge, even in Beverly Hills, they could have used a Starbucks cup to put his ashes in. So, I mean, the fact is, I'm not sure that he could have walked. He could have walked away. He was ashing, and even though it's a ticky-tack call, it's still a violation of the law. You could ask him his name. You could have given him an infraction citation.
Well, when the officers first stopped him, they asked him out the window, hey, can we talk to you? And he stopped and he said yes. So he could have said no and kept walking.
2 minutes remaining.
Thank you. Appellate discusses, he mentioned the three-pronged test that the US Supreme Court came up with in Graham versus Connor. And he argues that the undetermined warrants alone were not sufficient for the force that these officers used under these circumstances. But prongs 2 and 3 of that test are easily met by the fact that appellant was forcefully resisting after the officers attempted to arrest him. And the appellant's use of force, it does not matter that he did not intend to cause harm to the officers or that he did not direct the violence towards the officers, because there is case law that states that use of force by itself is sufficient to prove a violation of Section 69 of the Penal Code. In People versus Bernal, the court held that forceful resistance of an officer by itself
1 minute.
rise to a violation. Thank you. And then just briefly, the court was properly instructed on the requirement that the officers be lawfully engaged in their duties. First of all, the defense had the opportunity to review the jury instructions and declined to object to them, declined to revise them or modify them in any way. But the jury instructions were complete and the jury was adequately instructed on all relevant law.
I'm sorry. I know you want to,
Okay.
I'll let you sum up. I gave someone else a few extra minutes. The trial court said that they didn't really have to advise him of his arrest because the circumstances are such he should know about it. There are a lot of people that have warrants for traffic tickets and forget all about it. When the circumstances indicate that a defendant should know why he's being arrested, in the commission of a burglary, for example, when the cops go there, they don't have to tell them we're arresting you for burglary. So if you can respond to this, a warrant for, I don't know, traffic warrants, whatever they are, is something that is a little different than someone in the middle of the commission of a crime, isn't it?
Your time is up, but the judge.
I'm going to let you answer that.
I'm not completely clear on your question. Would you
Well,
mind?
I guess I was inarticulate in asking it. I'm saying, isn't there a difference between someone who has outstanding warrants and someone who's committing a crime at the time the officers arrest them?
Yes, Your Honor, but under these circumstances, Deputy Drucker had no way of knowing what the warrants were for, and he had to decide how to react as soon as appellant began to forcefully resist.
Generally, officers know what the warrants are for, I think. Well, anyway, I'll let you sum up. Go ahead.
Thank you. Deputy Drucker only heard the 1015 code, so he was not aware of what the warrants were for at that moment. But based on all of these reasons, we do ask that this court find that appellant's arrest was lawful and his conviction is affirmed. And I will pass the matter on to co-counsel, Ms. Maya. Thank you.
Ms. Maya. Okay, thank you.
Ms. Maya, you have 15 minutes.
You're going to have to unmute. There we go.
Thank you. Good morning, Your Honors. May I please the court? My name is Dalia Maya, co-counselor for appellant for the people of the state of California, the respondent. The trial court is not required to consider defendant's ability to pay before it imposes court assessment fine and fees, as stated by appellant counsel, Ms. Willis. A defendant's ability to pay fine and fees is evaluated in light of his or her total financial obligations, which include the assessments imposed on appellant under California Code Section 1465.8 and Government Code Section 70373. Both of those sections provide that an assessment shall be imposed on every conviction for a criminal offense to ensure and maintain adequate funding of court facilities. These two sections and these statutes justify the $140 imposed on appellant by the trial judge. Furthermore, the California Penal Code 1202.4 Section C states that the court shall impose the restitution fine unless it finds compelling and extraordinary reasons for not doing so, and state those reasons on the record. Defendant's inability to pay shall not be considered a compelling and extraordinary reason not to impose restitution fines. To add to Judge Bendix's question regarding the—
listen, gotta watch the screen.
Well, you answer you might be answering my question. I'm sorry to, well, my question, let me just say, in finishing your answer, please address, we do appreciate that the assessments and fines were mandatory. What the legislature provided, but the issue in Duenas was whether it could constitutionally impose that on someone who was destitute. So I don't think the fact that I don't think you need to address that because it's a constitutional argument. No one's arguing what the legislation says. But the question is whether, as applied here, it could be it was constitutional.
Of course, Your Honor. I will address.
Finish your sentence too, please. You in response to Bendix's question.
Yes, yeah. Thank you. I will get to both questions. Let me start with the first one, just to add to your question regarding extreme facts of Duenas. Duenas was a unique and distinguishable case, and it is not applicable here. Many cases suggested that Duenas was wrongfully decided, and several cases have rejected the Duenas analysis and the Duenas decision. She had been caught, as you stated, in series of criminal proceeding driven and contributed to her poverty. So that was kind of like a deviation from the common ruling and decision. The extreme facts of Duenas, they do not exist here. There is no evidence that appellant is unable to work due to any physical, mental, or emotional disability. He was not caught in series of criminal proceeding contributed and driven by his poverty, and he's not trapped in a cycle of repeated violation escalating his debt. And from, as discussed by co-counsel Ms. Patricia Snyder and appellate co-counsel, we can tell just from the facts of this case that he's able-bodied. And as I will discuss briefly in a minute, there is a chance for him to gain incarceration wages. Going back to your second question, if I may, the imposition of fines and fees is not a violation of appellant's due process for the excessive fine clause under the 8th Amendment. In the present case, Mr. Prescott has not challenged the fine as excessive, but rather he requested a hearing to determine if he had the ability to pay the order fines, which were imposed accordingly pursuant to the statute. So the trial court properly denied the hearing. According to 1202.41, the restitution shall be imposed on the discretion of the judge. And here the judge used her discretion to impose a fine of $500, a restitution of $500.
Can I stop you a minute?
Absolutely.
As to that particular financial burden, isn't there a 300 minimum? The judge doesn't have the discretion to impose under the statute at least zero. Isn't 300 the minimum?
300 is the minimum, Your Honor, and the max is 10,000.
Right. So the discretion, zero is not a possibility unless Duenas is upheld.
I'm sorry, can you come again?
Zero is not a possibility unless Duenas, you agree with Duenas.
I do not agree with the case of Duenas, but I was just mentioning the penal code regarding the discretion of the judge.
Okay.
My position is that Duenas was wrongfully decided, and I do agree with the many cases that rejected Duenas, such as People v. Hicks, People v. Casares, People v. Lowry, People v. First Kingstone, and this list just goes on. According to People v. Hicks, the imposition of these financial obligation has not denied defendants access to the court. Additionally, as also you further indicated earlier, the imposition has not resulted in additional incarceration. And in the case of People v. Hicks, the court held that should the fees and assessments imposed, should they remain unpaid at the time of the ending of probationary or incarceration, then the trial court will have to decide whether it was to defendant's indigency or lack of effort. At that point, however, due process does not deny defendants, there was no violation of defendant's due process right. I would like to also mention that in the case of People v. Lowry, the court concluded that we can infer that defendants will have the opportunity to earn prison wages, and they can start paying at least some of those financial obligations. It is illogical to conclude that appellants will not have an ability to pay and begin paying at least some of those imposed fine and fees while being incarcerated.
But you will acknowledge, will you not, that there's a much greater burden on the defendant who's already being sentenced to prison to pay that fine, as opposed to someone who has the means to do it. That sentence, if you will, is a greater sentence, a harsher sentence. I mean, isn't that a fact? I mean, I realize he may come into some money later on and all that, but the point is they're treated unequally. That is, the person with means to pay the fine and the person who doesn't have the means to pay the fine.
I would have to disagree with you, Your Honor. Actually, this provides a formality with court proceeding to impose fees depending on the severity of the crime, which is a factor, rather than what is their financial status is. That would actually differentiate between different group of people and make the proceeding unfair to treat somebody, a group of people who are wealthy with a group of people who do not have money. I think that would differentiate the treatment.
Okay, that's an interesting argument. It's similar, I suppose, to saying that if you're poor, you'll get a lighter sentence than if you're wealthy.
If there's indigency is involved, we cannot basically punish them for being poor and adding incarceration time to their sentencing. That would be unfair. But in this case,
no, I'm saying giving them a lighter sentence because they're indigent. I mean, I'm following up on your argument. I'm saying I'm finding an analogy. If you're saying, if in your criticism of dueñas, I could see that criticism applying if, say, you gave a defendant who is poor a lighter sentence than someone who wasn't. You were saying that would be an unequal treatment.
Well, I think right off the bat, that would be unfair. And that's where I strongly agree. Thank you. And that's where I strongly agree with the case of People versus Hicks, that at the time the payments are due, and which is not the defendant here was sentenced to 6 years, Your Honor, and he has 6 years to pay those fines and fees, not as mentioned by Ms. Willis, with all the respect, that they are due immediately. They are not due immediately. They are due at the time he serves his time. And
yeah, how's he going to pay him while he's in prison? He's going to get a few cents or $1 if he's lucky to get even a work assignment for a day's work, maybe. So, I mean, isn't it unrealistic to really think he's going to be able to make any appreciable payment while he's in prison for 6 years?
They do earn prison wages. That's that's just an option to pay those.
But I'm saying the prison wages are minuscule. It's money for cigarettes. It's not going to pay this fine.
They can't ask him there either.
He could get.
Well, I think the crux of the issue is, and we look at the Duenas and the Hicks cases, is when the fine is being imposed, is not being collected when it's being imposed. The guy can't pay, he's going to jail. He may be able to pay. He may be able to liquidate them right away if he's that wealthy. But I think the harm we see in Hicks is when it's being imposed after the fact, and that person doesn't have the ability at that time to pay it, then we have the issue. But we don't have an issue with when it's part of a sentence is to be imposed because you're looking into the future. So I think that where the panels disagree with Dwayne is that Dwayne is conflating the imposition at the same time as the harm that causes from the imposition. There's no harm yet because he's not being incarcerated for failure to pay. He's being incarcerated for the crime of resisting in this situation.
Sure, and I can't agree farther. I can agree more. You're absolutely right. Even if there was an error, that error is harmless because he's not being incarcerated or punished for not paying the fees immediately. They're not due till 6 years. Sure, Justice Bendix.
I'm having trouble following your argument because you're relying a lot on the fact that one could pay through prison wages, but defendants are put on probation many times, and they're equally poor. So does your argument depend on whether someone's on probation or can get a job in prison, basically, to pay it off?
No, Your Honor, I would still hold my argument the same. And I think the facts of the case of People v. Hicks, it was not a prison time, it was a probation. And again, if there is no harm right now when the fees are being imposed by the trial judge, assuming there was a violation, that error was harmless. And the court should affirm the trial court decision because there is no additional punishment. And again, there are different ways and things could happen throughout this 6 years period that would make him able to pay. And I think one of the justices mentioned something about solving this problem by doing community services. If we do, that is an option, and I totally agree with you. But if we do actually consider the ability to pay at the time the fees are being imposed and having community service as an option, what I'm trying to say here, it is an option which appellant attorney,
1 minute.
Thank you, appellant attorney has agreed with, but it interdicts her argument because if it is a reasonable option as she indicated, how is that going to play a role when you're dismissing the fees and assessment without giving them chance to do community services? Furthermore, and I would just likely to mention that I do agree with her as far as who bears the burden. The defendant bears the burden of proof. And according to People v. Cowan, which they disagreed with Duenas, which can suggest that the burden should fall on the prosecution. The defendant is in the best situation to know their financial situation and their financial status. And also according to Evidence Code Section 500, it states that the burden of proof should fall on the party or on the party.
Time is up.
May I just conclude?
Yeah, you can finish your sentence. Go ahead.
Thank you. On the party which seeking relief, accordingly, and according to the statutes, we ask the court to affirm the trial court judgments. If the court has no further question, with that, I submit.
Thank you. Thank you.
Your honors.
Mr. Sulemazian has 2 minutes of rebuttal.
Mr. Sulemazian.
Respondent is asking this court to hold citizens to a much higher standard than we hold police. I want to first respond to Justice Bendix's question of why the officers didn't just tell Mr. Prescott that he was under arrest and the intent and cause of doing so. Respondent here is misstating the record. On reporter's transcript, page 21, Officer Drucker is testifying as to his thought process. He told Mr. Prescott to put his hands behind his back because Officer Drucker intended to arrest him. However, the issue here is Penal Code Section 841 requires officers to share this thought process with the individual whom they are dealing with. Justice Gilbert, asked about Penal Code Section 841 and whether or not it applies to a uniformed or non-uniformed officer. And respondent answered with an argument about the authority of the officers. However, the authority issue is waived here. The only thing we are looking at in regards to Penal Code Section 841 is the information requirement. The information requirement has never been more important than it is today. Mr. Prescott was scared. He did not know what was happening to him. And when he asked the officers what was going on, the officers must inform Mr. Prescott of what was happening. They had ample opportunity to do so at any point throughout this interaction. The officers ignored Mr. Prescott, and Penal Code Section 841 does not permit officers to create a dangerous circumstance, which would therefore exempt them from this requirement. In that case, the safety exception would swallow the rule here. Police officers should not be able to grab people without warning. Mr. Prescott reacted reasonably under the circumstances.
Well, wait a second. Why do you say that? He had to be tased twice and had to call help, additional officers. All he had to do was to submit to the handcuffing and ask. I'm not sure his behavior was, I would say, was reasonable under those circumstances. I'm curious why you think so.
Your Honor, I see that I'm out of time. May I answer your question?
Of course.
Yes.
Justice Gilbert, excuse me.
No, sure, of course.
Thank you.
Your time is
Mr.
up.
Prescott.
No, just kidding, just kidding. Go ahead.
Thank you, Your Honor. Mr. Prescott acted reasonably because it was the officers that tried to grab him without warning. It's a natural reaction for someone to pull away at that point. That's when the officers then employed the use of a taser. So if the officers scare someone into reacting naturally and then employ higher and higher levels of force, that is not what an objectively reasonable officer would do. And we should demand better of the police here. Thank you.
Okay, terrific. Thank you very much. We're going to be in recess now while we ponder these interesting and challenging legal arguments. And we'll return in about 5 minutes or so. So I think we're going to be muted, and are we going to be blocked from view?
So if the justices could please hit mute and stop video at the bottom of your screen. Let's see.
Okay.
Justice Lui is muted.
He's really good at this.
The-
It's unusual for him to be muted. Okay.
So both Justices Lui and Bendix are now muted and gone. You, Justice Gilbert, are muted. Good job. And then stop video at the bottom. Hit that. There you go. Okay, so all three of our judges are now in recess, and they are going to confer. And when they are done conferring, they will return. In the meantime, first, a little housekeeping. We will have comments and discussion when they return. If you are attending this webinar and you would like to ask a question of the justices about the case or about their work, about appellate advocacy in general, you can put a question into the Q&A function, and we will, if we have time, can hopefully have someone answer your question. I also wanted to thank everyone for coming today and announce the winners that we do know of for the Traynor 2021. First of all, we have the winner of Excellence in Appellate Advocacy. That is the combination of the brief and the oral argument, which is what brought, and the top two teams in that combination meet in the final. So we can already tell who the two winners are of the Excellence in Appellate Advocacy. First place, however, was taken by Loyola, and second place was UWLA. So cat's out of the bag, as we talked about cats before. So now you know who the two teams were who competed in the final today. Let's see what else. We have the Gisnet Mandel Award for Best Brief. And the best brief was written by the team from Loyola. Congratulations. Second place was Berkeley. Third place was UWLA. And fourth place was Hastings. So congratulations on the brief awards. And finally, we have the Jeffrey Hall Wright Award for excellence in individual achievement in oral argument. And this award goes to the best oralist from the Saturday 2 rounds. So the highest scoring individual, this is not a team award, this is an individual award. The Jeffrey Hall Wright Award is named for a very brilliant and talented attorney who passed away last fall suddenly at a very young age. We have a biography of him in the program, which is on our website. So please read about Mr. Wright. The winner of the Jeffrey Hall Wright Award is Patricia Snyder, who got the highest score from the first 2 rounds. She's from UWLA, and she argued today. We grant the individual achievement in oral argument to the top individual oralists. So in second place, we have Michael Sulemazian, who you also had the honor of seeing today. He is from Loyola. JC Dean was our third place. JC is from McGeorge. Mari Tanabe in fourth place from Berkeley. Catherine Willis from Loyola is fifth place. In sixth place, we had Duke Cooney from McGeorge. In seventh place, Camille Wiss from Berkeley. And in eighth place, Sean Leahy from Loyola. The only award left to give is the Roger J. Traynor Excellence in Oral Argument. And that will go to the team who won today's final round. First place and second place will go to the runner-up. All of these will be posted on our website, traynormootcourt.org, where you can also find the program for the competition, which contains bios of our justices from today and a list of all the participants in this year's competition. Because we were anonymous throughout, now you can see which schools everyone came from. Congratulations for all who participated. I also want to thank you just personally, because doing this event online was brand new, and everybody's patience and good humor and spirit of, yeah, let's try it, made it really successful. And I think the students experienced what they would have experienced if they had come to our host school in person. So I miss everybody, but I'm so glad we were able to do it this way. Special thanks to everybody who pitched in and helped. So I'm going to go check on the justices and see if they're close to making a decision. Again, if you have any questions for the justices, you can put them in the Q&A. I'll be right back. I'm going to check on them. All right, we have a question in the Q&A. I hope we get to that. If anyone else has a question for the justices or the participants, please type it into the Q&A box. And I see that the justices have returned, and all three are on camera and unmuted. So
Unmuted.
Great.
Okay.
Well, we have to wait till the proponent.
Yeah. Okay. We'll wait till everybody else comes on. Thank you. Justice Lui, make sure I do things correctly.
So if the 4 advocates, the 4 students could put your camera on so the justices can speak to you. Thank you.
Here we are. Okay. And is Mr. Glassman going to join us? We don't want to leave Mr. Glassman out. He's the one who induced. Okay. Hi. All right. We're back again. I know this sounds like a cliche, but it's true. I think the very fact that you got to this stage shows how good both teams were. And we'll spend a couple of minutes, if you like, just, chatting a little bit about the presentation. This was a struggle for us. And in fact, when Miss Billington came on, she said, "Are you ready?" And we were still talking about it. So it's a very close call. And we have to factor in the problem and how you responded. It's really close. So if we didn't pick your team, don't worry about it. After due deliberation, we think that the winning team, it's very close, were the respondents, Ms. Snyder and Ms. Dahlia, Ms. Maya. Congratulations. The other team did an excellent job. The problem I'll just give you my quick comments and I'll hear from my colleagues. My quick comment is this is a very difficult problem for the prosecution. If I were deciding this case, I'm going to tell you right up front, I would dismiss it on an 11-18 motion, never grant this. This is my view. I don't know, my colleagues may have a different view, but I think this is a clear roust, and we have to look at cases from I think, a practical view as well. Now we're appellate judges, so we have a limitation. We have to consider the standards of review and consider what a jury may have found, even if we may disagree with the jury. But if I were the trial court and what I've seen here, I would have granted the 11-18 motion. I don't know, my colleagues feel, in a heartbeat. I think it was a really difficult problem for the prosecution. That doesn't mean the prosecution won because of that fact. But that's how I saw the case. Let's just talk about the case and then we can talk about presentation. Let's go from Miss Justice Bendix. I would say Helen because we're all friends. So Justice Bendix, what are your views?
Well, first of all, I thought that all of you had such poise. Even when you get an attack from three fronts, three experienced judges, I was very impressed. I think I would have hidden under a table if I went at your stage in life. I don't think I would have been very nervous about it. You all have that in common. I think that, and again, I think all of you knew your subject matter very well and were familiar with the case law. We're familiar, all of you, did your homework in the sense to see what did these justices decide in the past. I was impressed by that because most people forget about that, because ahead of time who your justices are, and it's important to know what they've thought in the past on a particular question. So I was impressed that you all did that. You all also had a nice beginning, middle, and end. You stated your opening proposition, supported it to the extent we allowed you to when we questioned, and then you all wanted to bring it to a conclusion so we didn't forget what the big point while you were here. So I thought all of you did that very well. I think Ms. Willis, if I could make one comment, I think sometimes you have to be more responsive to the question. You answered questions partially, but you didn't get to the main point of the questions. And I'll say from my point of view, I think the Duenas argument, the due process issue has to be front and center of your particular argument. And you have to address why it's a due process problem. And due process usually talks about access to court and so forth. And I thought maybe you could have directed your answers to the onslaught of due process questions we gave you a little bit more directly, if I had to make one comment. So I don't want to monopolize the conversation. I'm gonna.
That's okay. Sometimes there's an exchange. I didn't mention any individual performances. Before I turn it over to Justice Lui, let me do that just very briefly. What you all did, which you're not going to have to do when you're in an actual court, is tell us what the case is about. Because the justices know, we've read the briefs, we've had conferences on it, and you don't want to use that time. This is a case in which, and again, we know all that. And I wasn't going to interrupt you when any of you said that, because we know it's good to just get right into it and to get into the tough issues, the tough questions, and to think about the cases that are against you. And I thought that the defendant's side, the appellants, had a better argument. Because not that they argued it maybe better, but the point is the issues were much easier, I think, from my view, from an appellant side. But I thought you answered the questions, you had poise. And one thing you all did that I thought was just spectacular is you did your best to answer the questions. You didn't get flustered. I remember when I did my first moot court, I was scared. I couldn't eat ahead of time. I was an absolute nervous wreck. And it was a million years ago, before anyone was born, up in Berkeley then it was called Bolt Hall. And I was just, oh my God, I couldn't believe it. So anyway, there was poise and dignity, and you wouldn't be deterred. Well, what about so-and-so? You came back, all of you did that. And so I really think, I think you were all very, very, it was so close, I'm telling you.
It was.
It's hard to find a criticism. I really hammered, I think, Ms. Snyder quite a bit, because I thought she had an uphill battle. And maybe I was a little, I tried to think about other questions to make it tougher for the other side. But, and I think Ms. Willis, I thought you were quite good. I thought you had poise. We brought up issues, and you talked about Duenas, and also what you did that I was very impressed with. All these cases. I mean, you're mentioning all the cases. Look at our division has filed cases against Duenas. We have one of our colleagues, Justice Tangeman, thinks Duenas is right, writes dissents over and over again. So we're going to see how that plays out. And you let us know what those cases, you knew what the cases were, and you were taking Justice Tangeman's side and hanging in there. So I really have to compliment you, and all of you. Miss Maya, you know all the cases too, back and forth. You guys were throwing it around. Mr. Suleimanian had lots of poise and dignity, and just never flustered, not a bit flustered. In fact, all of you were that way. In many respects, I thought some of you were even better than some of the seasoned practitioners that we have. You were real. You're gonna do the profession proud. You really are. It was an honor for us to see students like you doing such a marvelous job, and you're going to add to the development of the law in California. And I want to turn it over to Justice Lui.
First of all, I echo all the things that my colleagues have said, because it was really terrific. I have a few things I want to tell you. First of all, private practice will be easy after you've done this, because coming to, I've argued maybe 150 cases in various courts, state courts of appeal, the Supreme Court, and Ninth Circuit. But you guys are just terrific. I mean, you did a great job. You're poised. You're comfortable with yourself. You know your material. Private practice will be a breeze compared to preparing for this. And, I think the worst thing to do is, if you have to go to Division 6 in Ventura and argue a case, I've been that. That's tough. This is easy.
Can I, Justice Lui, I think they would love hearing, just for a moment, that you represented me.
I represented Gilbert
in a case.
Gilbert versus Chang, which, you've heard of Marbury versus Madison. This case is bigger. Gilbert versus Chang was a case I did twice. it was involved the very important thing for judges. That is, can a judge with a term remaining leave judicial office and go into government practice? For example, a former judge wanted to become DA, but was blocked by the Attorney General. And so a judge who had term remaining could not retire and then, let's say, go become the governor's legal appointment secretary for judicial appointment.
Until the term was up.
Gilbert versus Chang was a case where the AG fought, and we had to do it twice. And Gilbert, after the case was dismissed, I think on technicality, we had Gilbert volunteer to be the plaintiff. And so I had to represent Gilbert. It was, it's hard to have a client like him, but whatever. But we won the case, and the AG declined to file a petition for review in the Supreme Court. We would have won anyway, but it was a very simple issue. And when you got down to it, when a judge leaves the bench, the judge is no longer a judicial officer, so that the constitutional provisions do not apply to a former judge. And that's important, because I think sometimes when you look at a case and some difficulty, there's an easy thread into many of these complicated questions that you need to find, because that's what really is the key to it.
If,
But, I mean, I
you
really
might
mean that
point
you
out,
guys were all terrific.
go ahead.
We enjoyed it. It's even worth it to Sunday. And I would advise you one thing, that if you have a friend who likes to smoke cigars, do not walk in front of Gilbert's house and ash your cigars in front of his, because you will be arrested for a felony. I tell you. He doesn't like smoking in front of his house. So I thought this was quite amazing.
I don't like smoking, period.
Ashes. You get a cup, you just, how about your hand like this? Anyway, thank you very much for letting me participate. I enjoyed it. And as my colleagues have done, and we have fun with this, because all argument can be all work. This is at least fun, and to hear young students do this. And I've been a lawyer a long time, and I know that you will do well for the profession and for your clients and for yourself and your family.
I had a question. If you want to be an appellate specialist, is that something that drew you to this moot court, or it's different than being a trial.
Yeah, much
Putting
different.
on a jury trial, and you seem to, by nature, the four of you seem to understand that difference immediately.
And the last thing I want to tell you is that I avoided moot court in law school like the plague. I never did a moot court, because I was a transfer student. I got myself out of doing moot court.
I want to tell you one other thing. I have to tell you. Justice Lui and I have known each other for over 45 years. We both started out on the municipal court together, and then he went into private practice and became one of the top lawyers in actually, I could say even in the country. He was voted one of the top 100 best lawyers over and over again, a managing partner of Jones Day, one of the largest law firms in the world with offices everywhere. And he did a lot of pro bono work. And this was one of the cases he took on. And there was another plaintiff, and that plaintiff we had lost, but we were able to revitalize the case. I urged him to do it, and I became the plaintiff. He did this pro bono, did an absolutely brilliant job. You can imagine the two of us working on this case together. That was quite an experience. And you can look it up, Gilbert versus Chang. But there's, I want to mention one other thing. Mr. Glassman is a deputy attorney general who appears in our courts all the time. And I'm not just saying this because he's there and, you have to do, this obligatory comments, but he is an attorney of such brilliance. It's really stunning. His arguments and his briefs, to have a professor like him, you don't know how lucky you are.
So just
I know they're from other law schools. I understand that.
I wanted to interject that there have been some questions from our spectators. So as we approach the top of the hour, there's one in particular of a student who asks, with People versus Cop in the Supreme Court right now, in our California Supreme Court, do any of you justices have any predictions on what will happen on this fines and fees issue?
Better not to do that.
I don't think we can.
I don't
We're
think it's
prohibited under the
Yeah,
code.
it's not we can discuss a case and an issue. And when we're discussing it with lawyers at special events for just judges, that's one thing. But I think it would be inappropriate for us to guess what they're doing. You know how we feel about it because we've written cases. So I'm not going to guess what the Supreme Court's going to do. I have thoughts about it, but I'm prohibited from the canons of ethics to discuss it.
I had another interesting question about the extreme fire conditions that we have in LA, and would that have anything to do with the importance of a officer stopping someone from ashing their cigarette onto the street?
Would depend on the fact situation. If they're in a forest where there are dry leaves everywhere and someone's even smoking, be a whole different case.
You know, Justice Gilbert raised a good point. You know, ashing in Beverly Hills has probably never been charged. Ashing in other parts of the county, where in poor areas where there's a stop. The problem here was the resist. You know, we used to talk about, you know, the failure of the defendants to be subdued when they were approached by an officer. You know, you see the minority families telling their children how to behave if you ever stop. That's the situation. This could have been de-escalated by the appellant situation here. You know, I've been stopped before, and people were looking under my car and I said, "Gee, is there some bomb under my car?" So you need, if you ever have in a situation where you're helping people look at the obedience to, you know, obedience to law. It's getting very controversial now because what's happening with in stopping situations, but it has to be de-escalated. I think that's the problem. The problem here is that it wasn't de-escalated. It should have been. You're not going to win. I mean, remember that if you have followed the trial and Chauvin's trial, you could see Spice Hammer telling Floyd, "You can't win." Well, he was already probably unconscious. You can't win. There's no way you can win in this situation. But I mean, Gilbert is right about there's a close caution whether we would all drop this case on 11/18 or not.
Yeah, I just want to, excuse me, I was bragging about everyone, and because Elwood handled that case, and now we're on a first name basis. But Justice Bendix, I just want to mention a few things about her that I meant. She was one of the top settlers on the Superior Court, an absolute star. She's a brilliant jurist, one of the best writers on the court. She has a style that gets right to it immediately. And in addition to all her talents, and she's so modest, she's down to earth, she's a real person. You know, judges are people. She's a wonderful musician as well. She played in the Bendix trio with her sister, who is a noted professor of medicine and discovered a cure for arthritis. Her mother, they performed all in New York. She is the Renaissance person and a very dear person and a very close friend. I just want you to know that these judges are well-rounded people. Just because they wear robes, you know, they're actually real people.
I urge all our participants with your talent, don't let it lie fallow. Even if you work in a law firm, then they're not going to give you their bet the company appeal when you walk in the door. I hate to tell you, but I don't think they will. But if you work in a firm, get a pro bono opportunity, you know, and get a chance to argue in court and to use all the very great skills you have. Well, and if you go into a public office like Mr. Glassman does, my daughter is in public service, whether it's being PD in the county, in the AG's office, in the DA's office, just remember all the issues we've discussed and the judgment calls you have to make, you know, in terms of whether to prosecute a case, whether to plead out a case. You know, there's so much judgment that's involved in representing someone fairly. It's not just the written law in a book, and all the kind of things that we've been discussing here, you know, go into being a good representative of your client and a good advocate. Just like all four of you, you knew your judges. You clearly knew something about us. And that was very, very, that's more than a lot of people do, I will tell you.
And if you ever want to have a judicial career, I think public service is important in pro bono activities. My God, I devoted half my life to being a pro bono lawyer for Gilbert.
And also having other interests are really important.
Right.
Don't just be absorbed in the law. Know something about history and poetry and literature and have other interests. You'll be far better at your profession. Maybe we can just take another question or two, because that's what I know you wanted to do, Ms. Billington. Are there any others?
Well, we haven't heard from our four advocates. If they have any questions for the justices as we wrap up for today.
I would just like to say thank you so much for being here and presiding over this tournament today. I watched all three of you in the doing live oral arguments, like in the 2nd district, and I was like being among superstars today. I was very excited. So thank you. This was a wonderful experience.
Okay, I think that does it, huh?
Thank you so much, justices, for joining us for this final
good day.
round. So exciting.
We enjoyed it. It was
Thank you, Mr.
wonderful.
Glassman. Man, thank you.
Thank you. We're very honored to have been selected to do this.
And we enjoyed doing it. And good luck to all of you. We have no concerns about how the judicial profession will fare with advocates like you there. Thank you.
everyone.
To the
Bye-bye.
four of you, congratulations. To every single person who participated this year. It was quite a remarkable, unique, first-time experience doing the Traynor this way, and it is thrilling to see that it worked, and that's because of all of you. So thank you so much.
Do we
And
know who the
yes.
winning teams are, what schools they're from?
Oh, do we get to know what schools or do we?
oh, they
not?
don't know. Yes. Would you like to let them know, competitors?
We're from the University of Los Angeles.
I'm sorry, from where?
UWLA, University of West Los Angeles.
Oh, okay.
We are from Loyola Law School.
Okay, terrific.
Well,
Wonderful. Okay, terrific.
they're in
Thank you.
good hands, right? Those schools?
Congratulations. again.
Congratulations. Okay,
Bye-bye.
everybody.
Bye-bye.
Thank you so much.
Thank you.
Thank you.